Okay, hi everyone. Happy New Year. Although it's now the end of January, it's great to be speaking to you all again. And when I was asked to do the session about all the changes, it was still at the end of 2024. And by the time I was putting the full presentation together, we're already into, end of January. So I've tried to incorporate as much as possible the insanity of the last couple of weeks. Every day we're seeing new developments and they're happening on multiple fronts. So I've tried to the extent possible to really tackle this. And it's probably by far the most wide-ranging presentation that I've done in a long time in terms of covering a lot of different topics. So please bear with me as I go through them. I'm happy to answer questions as well, but I will try to break periodically. If you do have other questions, please put your hand up. And if I don't see it, I think perhaps Mr. Mansouri, he can stop me and let me know. So I'm going to just jump right in. The circumstances in which we find ourselves today are very different to a year ago. And last year, we already knew things were going to change. I'm going to start with a discussion of changes to the international study program that started from the 1st of January 2024. But last year, we had the changes to the levels plan that came in, and we saw that even though the government had planned to increase immigration levels up to 500,000, and we already knew that was not going to match up with the temporary resident levels due to everything that's happened over the last year and a half. They drastically reduced these numbers. So the top chart that you see is the previous levels plan, and the bottom one is the revised one. So they went from a goal of 500,000 to 395 for 2025, which you can see is almost, 90,000 less than what 2024 was. And it's going to pretty much stay at the same level, go down a little bit for 2026 as well. So not only do we not have a solution for the temporary residents who are already in Canada, which were far increased, we actually have far fewer numbers in terms of people being able to apply for permanent residence. I didn't put it in the slides, but the government has now also put in what they say are forecasts for how many temporary residents are supposed to be permitted to enter. And a big part of that is that they somehow believe, approximately 1 million temporary residents, visitors, students, workers are going to leave Canada over the course of the next year or two. So all of this is huge changes, structural changes, and it's having an impact on every single area that we work in. The other big, change, other than the internal conversation in Canada around immigration and the scapegoating of a lot of various economic issues on, international students and immigrants in general, we also have pressure from our neighbor to the south. So with the coming into power of the new government in the US, Canada's focus has sort of shifted in terms of immigration. The slide that you see here is from, strengthening the border sort of documentation that IRCC has been putting out, trying to show that, we're tough on immigration, we're tough on borders. And you'll see that there's been, this idea that we're increasing refusal rates, we're increasing misrepresentation investigations. According to their own statistics, they have a 600% increase in potential misrepresentation investigations. And I have some data on actual misrepresentation refusals too. And this 600% is just in the course of 1 year. They're also in the middle column, you'll see that they are boasting about increases in refusal rates. And it's a very different world that we live in today compared to, let's say, 8 years ago when the US tried to make it more difficult for immigrants. And our prime minister came out and said, Canada's open. This time around, it's certainly not the case. They're saying we're sort of in lockstep. We're going to also be very restrictive in terms of allowing new applicants to come in. And you'll see as we go through and discuss so many of the changes, they're all focused on reducing intake, but also trying to get as many people to leave as possible through lots and lots of different methods that they're going to use. So we'll jump right into. I will spend the first part of the presentation talking about a lot of the changes on the temporary resident applications, and then I will also spend some time on the permanent resident applications, as well as citizenship and some other changes that have been made. So for the study permit applications, jumping right in, starting as of the 1st of January last year, there were caps put into place as well as additional requirements in terms of financials. I'll talk about that in a moment. But those caps have remained in place. The total number of study permits that are intended to be issued this year are about 437,000. There's a little bit of discrepancy between these targets that were published on the website and also numbers that are found within the levels plan that the government published. But this would be the best case scenario in terms of how many potential students would be able to come. And the distribution of that, we still see, a big portion of that is going to, the bigger provinces, Ontario, Quebec, British Columbia, and, sort of following behind, we have Alberta as well. But these numbers are all reduced from prior numbers. And if you follow the news, you're seeing that colleges, universities, they're reducing their courses. It's already having a knock-on effect. The other big change that came in last year and has now been extended as of 2025 is the requirement for provincial attestation letters. There are very few limited exceptions to who needs to have a provincial attestation letter or a PAL when they submit their application. And pretty much at this point, the only exemptions are if it's, a school, so preschool, primary, secondary school that the student is going to be applying to, or vocational programs in Quebec. You, even as of right now, need to have a new PAL if you are submitting an application for a new study permit. That's going to be okay, so this is the exception. Sorry, I jumped the gun a little bit, but the only time where you wouldn't need a PAL is if you're studying at the same institution and at the same level. Let's imagine that someone has finished a master's degree at the University of Toronto and they're going to have another master's degree at the University of Toronto. They wouldn't need a PAL. But everybody else, including master's students and doctoral students, do require these attestations. That wasn't the case last year for the graduate students, but now they do also need this. And something very sneaky that has been added in to the instructions, and I found this when I was reading it last week, is that they have now said if somebody applies, they obtain a PAL, they submit an application, and their study permit application is refused. They want to reapply. Now they have to obtain a new PAL. So that PAL will have been used up. I don't know how that really works, but it's not like they've come and registered or whatever. Like the university or the college has used one of their quota to give that student the ability to apply, right? So this is going to be a challenge, I think, for people. I mean, there's limited number of these. They're not given to everybody. And so if you are refused, is the college or university going to reissue a new PAL for the applicant? If you do apply without a new PAL, the application will be refused, at least because of that, if not for other stupid sort of Chinook-based reasons. So I think that I've already had questions about this from people whose study permit applications are refused, who are deciding that they want to apply for judicial review instead of doing a new application because they're afraid that they won't be able to get a new PAL for their new study permit application. So keep that in mind. And as I said, there wasn't a big announcement about this. This is just, updated details within the website. And one of the absolute top tips that I can tell you to sort of walk away with is every single application that you're doing, you need to go back and review the requirements for the program one more time. It isn't the case that, we know this thing, we know it inside out. They are literally making changes to everything on a daily basis. So making sure that applications meet the latest requirements is going to be critical on a going forward basis. Okay. So that's with respect to PALS. I did mention that as of last year, we also had the update to the financial requirements. So this, it used to be 10,000 and then it would go up by family members. And now these are, as of today, the required funds that applicants have to show based on their family size. The other important thing that I think has really come into focus, including from a lot of the federal court decisions for refused study permit applications, is it's not just sufficient to show these funds that the applicant has them, for example, in a bank, or that their supporter has them. They have to be able to demonstrate source of funds, and they have to follow the visa office specific instructions. And there's been several cases where, for example, applicants provided bank letters, but not bank statements that show transaction history. And the visa office for their country, for example, Ankara, typically requires that. It says that that's one of the documents you should provide. And if they haven't provided it, and the refusal references the lack of financial proof of source of funds or lack of transaction history, then it becomes pretty much impossible to overturn that decision. So making sure not only are applicants meeting these higher requirements, but showing very clearly what the source of funds are with everything that the visa office asks for, but also creative thinking, right? Depending on, the circumstances of applicants, they might have various assets that are income bearing. They might have income sources from, investments that they have and so on. So providing additional evidence is really important to be able to continue to meet these requirements. The other change, I'm going to use that word change like a million times today, so just bear with me. If applicants need to go to a different institution, previously, if it was at the same level, you would not need to obtain a new study permit. But as of November 2024, if an applicant is going to be studying at a different designated learning institution, they have to apply for and obtain a new study permit. This is a must. And this is the one that I kind of alluded to earlier. They also need a PAL to be able to do this. It's not just that, you're already a student in Canada, you're just switching your university or college. No, you also need to get the provincial authorization letter. So all of this is this idea of really restricting the student numbers, right? Practically speaking, if you're trying to help an applicant sort of work their way through this, one of the big challenges you're going to face is the processing time. As of this week, the processing time for a study permit extension inside of Canada is about 120 days, right? That's a long time. Depending on, when the study permit the applicant has is expiring and when their next program is starting, this requires maybe advanced application for that change, or having to change your student status while they wait inside Canada, which can get very complicated. But this is, discussions of these changes, I hope, will help because you can have earlier conversations with clients, develop strategies, and excuse me. It requires us to think differently about how we advise our clients. A lot of times, when they get approved, we send them the approval, closing letters, and, we're done with them. Particularly for temporary residents, it's not going to be like that anymore. And I would advise that if you want to sit down with them and talk about the various essentially risks that there would be and things that they would need to be aware of as they might need to change their status on a going forward basis. So for example, when students arrive in Canada, not only are we going to be talking to them about, the various conditions I'll get into in a few minutes, but we can discuss things like if you need to make changes, there can be several months of lead time. So make sure you get in touch with us early enough so that you're not going to be left in a situation where you are either out of status or forced to leave Canada. And with the current circumstances, you might not be able to return. Okay. Off-campus work. So with the pandemic, we had the government was very optimistic, and we had the situation where it was pretty much unlimited work. And that was taken away. And now we clearly have guidance as of November that students can work, full-time students can work up to 24 hours a week off campus without a work permit. Faribajan, you have a question?
Sorry, yes, I do. Do you mind or I can wait?
Sure, go ahead.
Um, I have a student that was refused, and then after the judicial review, they have opened the file, so we submitted all the required documents. But that was from the Centennial College. They have closed 45 programs, which one of them was for my students. So what I'm doing right now is getting another acceptance letter from another college
Mhm.
to inform the officer that we are aware of that and we are in the process of getting another one.
Mhm.
But should I complete a new application and send it to him, or that would be enough? And do I need another PAL?
Um, if you, so it does get complicated in these kinds of
Yes.
situations because you have the study plan, like
Yeah.
why the student wants to come, and they explain in that, why this college, why this program, how it impacts their career. If you're able to get something that's very similar, but from a different college, I think it's possible to continue on the same application. But what you would need to do is very quickly not only get the LOA, but also get the PAL to match with that and submit that before they make a decision on the application. Because otherwise, if you don't have a PAL, and you only submit the LOA, I think you'll run into this problem that you're submitting an application to a different program that you don't have a PAL for. It's not to do with the timing of it. It's just that those PALs that you're issued with are for specific programs in universities or colleges. So I would suggest that you get both of those and submit it because they would be able to look at it, and you would have to update the study plan as well and say, well, there's been changes in that college, but this program is substantially the same and will give you the same benefits, and be able to explain it with detailed reference to the
Hmm.
courses, reference to the opportunities that are available. Yeah.
It's close, but it's not exactly the same one. So
Yeah.
it seems to me that I have to start all over again, prepare the study plan, application. I've requested for the PAL too.
Mhm.
The acceptance letter would be ready tomorrow, but I just emailed them that, make sure that they will send me the PAL too.
Yeah.
But this is very unfortunate, I mean, it's out of the students'
Yeah.
control,
Yeah.
and the officer should give us some time to be prepared. And I'm scared that he will make his decision before I submit all these documents.
Yeah. Yeah. Unfortunately, as you'll see it with everything else that I'm going to speak about today, they have no sympathy. Like, even if there was a tiny bit of sympathy on the other side before, now it's just a focus on trying to reduce numbers. And I showed you that infographic that IRCC put out. They want to increase their refusal rate. So
Yeah,
it's very unfortunate for applicants.
very unfortunate. Yeah. All right. Thank you very much. Sorry about that.
It's okay. We have two more questions. Charbel.
Hi. Okay, my question is, we will mention if the student was approved and they switch the DLIs, like colleges, they have to get a new PAL. what if they switch just courses within the same college?
If it's at the same level, so let's say, it's a postgraduate diploma in A and they switch to postgraduate diploma in B, that's okay. If it was, let's say, a bachelor going to a master's at the same university, then they would need a new PAL and also a new study permit. But if it's at the same level, they don't need that.
Okay, and then do they have to, if they've been approved already, do they have to inform immigration or just go to a new course and that's it?
I believe they can go to the new course because they don't need a new study plan, a new study permit.
Okay, perfect. Thank you.
No problem. Behruz?
Yes, hi. That's policy that student can work up 24 hours starting November 2024. Does the students that are at the high school level includes to this policy or not? They're 14, 15 years old students.
I believe they restricted it and now it's post-secondary, but I'll have to go back and check. Honestly, guys, even though I spend so much time every single day reviewing these things, when you ask me a question like that, I don't have the confidence to say it with like full force that yes, it is or isn't. I will always go back and check as well, just to make sure that it is in fact the case. But I'm pretty sure that when they made the restrictions, they also said it was for postgraduate, sorry, for post-secondary. Again, trying to limit who can access these things. Part of why I say that is because when they were doing the limitations on the spousal work permits that I'm going to talk about, they said that dependent children would no longer be able to apply. So that's where my thought is coming.
Right. Let me elaborate on my question. If there's a mother with an Iranian work permit, has a son in high school, this person is 15 years old, and immigration doesn't have any age limitation for a person to apply for a work permit. And Ontario work legislation doesn't have any limitation as well. So before this limitation came to force on January 20th, I applied for open work permit for this child.
Mhm.
There's no restriction, and this guy is 15 years old. So legally, is there any restriction before this January 20th, or this application might be rejected as the officer discretion? But legally, is there any limitation?
I don't think there's any limitation if you apply for the work permit and you meet the conditions. I don't believe the policy has an age requirement on it. This is for the permission to work off campus without a work permit for full-time students, which is different from what we're talking about. If you apply for a work permit, if you meet the conditions, it should be approved. So, that's a really good question. I haven't seen that circumstance, but I would imagine that if it's permitted, legally permitted for the person to work under Ontario law, then there shouldn't be a limitation on them of being able to obtain the open work permit if they are, an Iranian citizen and therefore they meet the policy requirements there.
Okay, thank you.
Okay, no problem. A couple of things I want to clarify with regards to work. And we've sort of had some of this before, but it's becoming even more important because, as I said, they're looking for ways to refuse people, but also when people later are trying to apply for their postgraduate work permits and so on, if they've engaged in unauthorized work, that's going to be problematic and it could lead to the refusal of their application. So be very clear with your clients that they can only work under this 24-hour rule from the time that they actually start studying, and they have to be a full-time student. The only time, for example, that they can be a part-time student is that very small limited exception, that's for their final semester of studies. They can work during breaks in their study in terms of holidays. So like the summer holidays, they can work over the winter holidays. But if somebody for example, arrives before their program starts, right? Let's say they arrive here 2-3 months before their program of study begins, they are not authorized to work in those few months before they start their actual studies. If they take authorized leave, they're also not permitted to work at that time either. And if they finish one program and are switching to a program at a different school, they're also not permitted to work during that gap until they get their new study permit and they get their begin studying so that they can actually be authorized to work. So if they are later going to say, on their documents where it becomes clear when they're applying for permanent residence or a postgraduate work permit later that they did engage in unauthorized work, that could lead to concerns about inadmissibility, right? And we've always had, I forgot to write the provisions here, but we do have, if someone has engaged in unauthorized study or unauthorized work, it can lead to them not being able to work for 6 months. The rule is that they would not be able to, the officers would not be able to issue them with a new work permit or study permit because they are outside of this. Charbel, you have a question?
Okay, I have a case. This client, the school sent him a letter that for the next 2 semesters there is no classes because there isn't enough student. So this is 6 months he's off. And I looked it up. I think I did lots of research. I think he was authorized to work only 5 months out of these 6, but I wasn't 100% sure. I told him, like, don't take my word. It's not my client, actually. It's somebody who approached me. So I said, don't take it 100%, but this is what basically I found out. And if you need to hire me, then I'll check for you, see exactly what's going on, because I have to put more time on it.
Yeah.
What do you suggest in here?
I think it depends a little bit, but that's a bit of a unfortunate situation because he's not studying, and I'm going to actually get to this. I'm going to park that question, and when I'm talking about restrictions on the study permits, I'm going to address that, okay? I already talked about that you can work if you're a full-time student during the scheduled breaks in the year, and you can also work if you've applied for your work permit before your study permit expires. So typically, this is what we say, a postgraduate work permit applicant, if they submit their application while their study permit's still valid, then they can commence their work on a full-time basis. Also, if you're starting a new program study at the same institution, you can continue to work. For example, let's say you finish up at Centennial in May, and your next program at Centennial at the same level is going to start in September, you would be permitted to work during that summer. Okay. This is with regards to condition and validity of study permits. And it wasn't 100% clear before on this particular point, but now they are very clear on it. And this is extremely important, and it's very confusing for applicants. So please pay attention to this and make sure you convey it to your students, and it applies to everybody. It's not just from students, from now onwards, it's for anybody who holds a study permit. So typically we think of a study permit being valid until the date, that's the expiry date on the study permit, right? Like you think if it's valid until 2027, the person is here as a student until 2027, right? That's not the case. A study permit is valid for either the length of the study, it's valid for the length of the study of the program plus 90 days, okay? So let's say somebody comes, they plan to do a 4-year program, they get a 4-year study permit. But then either they complete the program faster or they switch to a different program that's shorter. And let's say their studies end after 2 years, right? They don't just have another 2 years that they can stay here as a student. That's not the case. 90 days after they finish their studies, their study permit is going to expire. And this is extremely important because, again, IRCC is looking for any excuse to find people inadmissible, right? So students have to be really careful about this. And what they mean by when your program is finished is one of 3 things. It's a date that they will receive their completion letter or their transcript or their degree. And I think I would go with whichever one of those is first, right? So as of that date, up to 90 days afterward, that study permit is expired. So they would either have to, if they can, apply for a new study permit or apply for a work permit. And if they can't, apply for a visitor record in order to be able to maintain their status here. They cannot just hold on to a study permit for an extended period of time and think that they are still a student here. That's important because let's say that happened and after 6 months, 8 months, they find a position they want to apply for a work permit and they think, well, I have a study permit, so I can do an inside of Canada work permit application. They can't, because as soon as they fill out their forms, it's going to be clear that they have essentially been without status, without proper status from that 90 days until, whatever time that they're applying. So this is a tricky one. It goes against what we would think because the document clearly says this paper is valid till X date, but the condition of it is that they have to be studying full-time, and if they're not, and their program is finished up to 90 days after that, irrespective of what it says on their study permit, their study permit is going to expire. Please keep this in mind. So Charbel, sort of going back to your question, it's a little bit confusing because I'm not sure that how that break would be treated. If it was a normal authorized break, it's up to 150 days. And sometimes that break might fall in the following, the summer sort of adds on to it. But I think if someone is actually out of their studies for that period of time, then it could be argued that they're going to fall, like their study permit's going to expire in this way. I think that, depending on what the case is, we'd have to sit down and think about it. I can't come up with a blanket answer to that question at this point because it would have to be how many people are impacted. Is this something that IRCC is going to accept later when they look at the documentation or not? So there's no easy answer to that, but this is another important part of that discussion of whether that person even has a valid study permit or not. Okay, moving on. Big changes that came in with regards to the spousal open work permit. And it's interesting again, because over the last couple of years, Canada became much more accepting and open in terms of granting spousal open work permits to more and more applicants. And the idea was that, if someone is already here, their spouse should be able to work and also contribute to the economy and also support their family and so on. Now we have a complete U-turn on this, and the latest changes that came into effect as of last week severely limit who can apply and qualify for spousal open work permits. And it is not going to be easy for a lot of people because I think it's going to mean separations of families. And I think over time that the idea is that they want to discourage more people from coming to Canada. My personal thought on this is that it's going to discourage the wrong kind of people from coming to Canada, the ones that have options, the ones that can go to other places and make sure that their spouses are able to work, the highly educated, the ones that have a lot of skills that are needed. On the other hand, it might not really have an impact on people that are going to come here because like anything is good enough for us. So what we're looking at for international students, for their partners, in order to qualify for the spousal open work permit, they either have to be in a master's program that's at least 16 months. It wasn't the case necessarily before. It was obviously before it was just master's, but now they've said that it's not just 1 year master's, it has to be a 16-month master's. So essentially, for the most part, that's 2-year master's programs. Students are in doctoral programs, and there's certain other eligible programs. For the most part, a lot of those are professional degrees, so like medical school, law school, dental school, pharmacy, and there's a couple of other ones in there like nursing as well. With respect to foreign workers.
Sorry, before you move, if it's 16 months, but they register they finish it earlier, that's fine. But the program is 16 months in design.
So you're saying if the program is 16 months for the master's, but by the time that they apply, it's past that? That's a good question. Again, this is one I would have to go back and look at. It's so new, because I do know that with respect to foreign workers, the date that the IRCC receives the spousal work permit application, there has to be at least 16 months of validity left on the main applicant's work permit, but I don't know for the master's degree if they have, during the break, I'll take a look at that. If they have to apply essentially at the same time as their spouse, because, in order to qualify for that 16-month program, or the fact that it's a 16-month master's, they'd be able to apply. So I'll get back to you guys on that after the break. But for the foreign workers, for sure, they have to have at least 16 months left on the main applicant's work permit validity. So either they're applying together, in which case they're applying for a work permit that's going to be more than 16 months, or if the main applicant already has a work permit, as of the time the IRCC receives the application, at least 16 months is left on that work permit in order for them to qualify. That's one condition of it. The other condition of it is it's severely limited in terms of who can apply. So it's kind of going back to the idea of the skilled workers. Before, the open work permit was not available to all workers. It was only really available to people who were in skilled occupations. So it's pretty much the same. If the main applicant is working in tier 0 or 1, their spouse will qualify and meets the 16 months, their spouse qualifies to apply for the spousal open work permit. And if they're in tier 2 or 3, they have to be linked to labor shortages, and they just published what that list consists of last week when the regulations came into force. That's one that you want to keep going back to and make sure that if your client's thinking about this, that their work at tier 2 or 3 at least falls within that list of potential occupations that can qualify their spouse for the work permit as well. Yes, Sharbel?
So does this apply to, for example, if so foreign worker already in Canada for the past 2 years, and now we are doing a new LMIA and work permit. So if he's tier 2 and he's not essential, so his family has to leave?
His family, like his spouse, would not be able to apply for open work permit.
So she either
So
can stay as a
they would,
visitor.
exactly, that's it. They would either have to leave
What
with,
about the children? I was reading, it says somewhere the children, if they show money, probably the children can still go to school. Like, I don't know what they mean they show money. Do they have to pay as foreigners or just show money that he can support them? I didn't know, but I want dig a lot about this and this is what I found.
yeah. Again, remember, all of this is trying to force as many people to be uncomfortable enough that things are difficult enough for their families that's going to push them to leave. So, it's a bit complicated because in certain places like Ontario, it is possible for you to go to school, to local schools, even without a study permit. You can do it with a visitor record. You need a study permit. And you don't have to necessarily pay international tuition fees. It might be different in different places, but the children could remain here with visitor records and go to school. The spouse would definitely have to switch to a visitor record or maybe a study permit, or if they want to apply for a work permit, have some kind of LMIA or meet an IMP exemption. Yeah. Nasreen? You're on mute.
Muted.
Yep. Can you
Hi.
hear me
Yes, we can.
now? Okay, great. One of my clients received a late approval, a study permit late approval. So she couldn't attend the classes. And also, there is no term for spring. So the university deferred to fall. But now what is the situation? Can she enter in Canada or she has to wait until summer?
That's a really good question. I actually had the exact same situation, and it's not an easy conversation because there's all kinds of risks, right? And we sort of talked about it before the session began. There is a lot more scrutiny that's happening at the airport when students are coming in. So there is, and my approach to this is like to make sure that the clients are fully aware of what the risks are. So if they come earlier, and present the acceptance, the letter of acceptance that's for September, that officer could say, it's not about entering, but it might be to do with, was your PAL for this year of study or was it for the prior year of study, right? It gets complicated in that sense. And if they are not accepting, if they come and they have an officer at the port of entry that is very strict, they could be asked to leave, and then if they do, then they have to reapply and submit a whole new application. When I discussed the situation like this with my client, I actually told them you can potentially go back and talk to the college and ask them if they're going to support a PAL so that when you're coming, you can have that says, we support this application, even though it's been deferred and it's approved because it was the same program. But then they're going to have a PAL in place in case the officer in the airport is going to ask them more questions of whether this is going to fit into the quota that's for your, college or province. There are going to be a lot of messy little situations like this, and I think it's going to be very difficult to advise people. Make sure you put it all in writing because your clients will forget that you told them what the risks are. And when
Yeah, it's
things
very
go
important.
south, they're going to say, well, I didn't know that was going to happen. If I had known, I would never have done it. I had a penny for every time I heard that, right? But if you have that in writing, that you have explained the various risks, then at least you've done your duty. We're working in very difficult circumstances right now, where not only are things changing, but there's not a lot of honesty on the part of the government in terms of how they're implementing their own policies, and that puts a lot of risks on us as practitioners. And when things were very open and there was a lot of easy, I want to say, approvals compared to today, our clients were far more happy as opposed to upset. But in this situation going forward, there are going to be a lot more refusals, and not just refusals of people who can't get a visa, but like people who show up at the airport, people who are here and now going to find themselves facing allegations of misrepresentation. And it's going to be extremely important for all of us to sort of adopt a kind of practice that is trying to minimize risk, right? Risk to ourselves, risk to our clients, 100%, but also risk to ourselves, because as I just said, if you explain all of that and the client is aware of it and then they make their choice, they're making an informed choice. But you don't want them to come back later and say, I made this choice, but it was your fault. If you
That's
have
right.
the documentation to back that up, and that applies in all kinds of circumstances.
That's right. But Zainab, one thing, the student actually received the Quebec certificate for the duration of her study for 4 years.
Oh,
So in
so
this
that
case,
helps. This is a better situation, right? So all of this is very
Mhm.
fact specific. In that situation, those CSQs are different. The PALs are really issued for like a year, but the
Right.
CSQ is a longer term document. So I think that weighs in favor of her having less of a problem when trying to come in because her CSQ is valid, right? That's the clear authorization she has from that province.
Or maybe she can register in another private institute. I'm not sure to explain to the officer that, okay,
Why
instead
she's
of
coming.
university for this time, I'm attending, for example, for French
Mhm.
classes.
Yeah, that's also part because for that you don't need a study permit, and it would be a good
Yes.
explanation of why she's coming in earlier than her program
Early.
was starting. So that would be something that she could do, and particularly because her program is not changing. It's just a different start date, right? So, and the CSQ for that. So
Okay,
that's a better
thank you.
situation. Yeah.
Sure, thank you.
No problem. But that's an example of a situation where the specifics is going to make such a difference, right? So every case you're going to go through and do that analysis and keep a track of that because I'll talk about this later, but I just touched on it. The risks that are facing us as professionals in this area are becoming much more pronounced, and it's going to be even more challenging moving forward.
Correct. Sure, thank you.
No problem. Okay. I'm going to talk about postgraduate work permits. So we knew these changes were coming, and they finally came into effect as of November this year. And there's two different aspects to it, but I'll go through them. So applicants already had a study permit or had submitted their study permit application before the 1st of November 2024, the only thing that's going to apply to them is the language requirements when they apply for their postgraduate work permit application. This is different from applicants who are going to be applying for their study permits after the 1st of November 2024. They will have to meet both the language requirements, but also program and field of study restrictions. So the language requirements will depend on whether it's a university program or if it's a college program. Pretty much rule of thumb, the higher level university programs, they will have to show a valid language test, CLB-7. If it's a college program, CLB-5, at the time that they want to apply for the postgraduate work permit. And remember, everything else in terms of eligibility for those remains in place, and they're being far more strict, right? So to qualify for the postgraduate work permit, you have to apply within 180 days. You have to have studied full-time except for your last semester. You have to provide the exact documentation that's required to prove that you've completed your studies. And in addition to that, you need this. And if you go back to, my points earlier about making sure that the students did not have breaks in their studies or unauthorized work, those things are going to be extremely important in postgraduate work permit applications going forward. And I will also add this: if there are students that face challenges, face problems, have gaps in their studies, it's not necessarily the case that they can't get postgraduate work permits, but it's going to be extremely difficult. We've been applying for those based on, with evidence of why it is that they had those gaps, sometimes submitting the applications along with TRPs. And, up until last year, we've had good success. I think those applications are going to be more difficult to get approvals for going forward, but it is still possible to do. But I don't think if somebody doesn't have the language requirements, they will be able to overcome that with, explanations and documentation. Those are going to be things that IRCC wants to see. And if an application is refused, I don't see the court being able to say, well, we could excuse this and they could have a lower language test result. In terms of the new applicants, the ones who are applying for study permits or have applied for study permits since the 1st of November, if they're applying to a university program, for the most part, they do not have a field of study restriction. But if they're applying for a college program, then they will be. Sorry, I'll make a distinction. If they're applying for the bachelor, master's, doctoral programs, they will not have a field of study, but other university programs, because sometimes you have diploma programs that are offered by universities, those will have a field of study restriction on them. So keep that in mind. Charbel, you have a question?
Quick clarification.
Yep.
Clarification. So basically, when they applied for the study permit, they get affected with these changes, not when they are applying for the PGWP.
Yes. Because if somebody, the idea is like somebody might have applied last year thinking that their program is going to allow them to be eligible for a postgraduate work permit. And if the rules change, that's highly unfair, which is really good of IRCC to acknowledge because they don't always take that into consideration. So if somebody went to a college program, a 2-year college program, they started last year, then they still will be able to qualify as long as they have the language. But people are now on notice. If you apply for a 2-year college program now, January 2025, if it's not in one of the eligible fields of study for the postgraduate work permit, then even if you have, CLB-7, it doesn't matter. You won't be eligible for the postgraduate work
Sorry,
permit.
but when they applied or when they get approved or when they started?
When they apply.
Okay.
When they apply.
Okay, sure. Thank you.
Because again, it's a knowledge point, right? Like, did you know at the time you applied that your program was going to be postgraduate work permit eligible, or you didn't know it was going to be postgraduate work permit eligible? Okay. We're just going to go through the rest of the. Okay, I'll go through visitors for now. Changes on the visitor side. We know that big one was the reintroduction of the Mexican visa requirements. The other huge one is everybody's dealing with this insane, very high refusal rates for visitor visas. They just are not even looking at most of the applications. We work on a high volume of these for judicial review, and 99.9% of them, they come back with extremely generic refusal grounds, and it does lead to success on judicial review. But what it means is that when you're discussing that process with your clients, you're going to be talking about the refusal rates, managing their expectations of you probably either will have to go to court or you're going to not have an opportunity to be able to get a visitor visa in a lot of circumstances. And we're seeing refusals for even people who were previously accepted and had visitor visas in the past. Also, for those who are parents, right? Sorry, one thing I forgot to add here, and I will add that in, it was the change they made with regards to single entry and multiple entry for visitor visas. So for many years, since 2013, I believe it was, they changed it and everybody was automatically considered for a multiple entry visa. And now it's been changed. Everyone is going to be essentially applying for single entry. If you are applying for multiple entry, you have to provide explanations and justification of why you need a multiple entry visa. So there's certain, again, like parents, if they're not applying for a super visa, they might say, I want to be able to regularly go back and see my children. Or you can imagine if someone has an international student child here, they want to be able to come and visit them regularly. They don't qualify for a super visa. But if it's somebody who's saying, I want to come for a tourist, I want to go see Canada, for the most part, a lot of those are just going to be single entry applications now. And one other sneaky thing I do want to talk about is the validity of visitor records. Sort of similar to what I talked about in terms of study permits, the visitor record is issued to people if they make an application, right? Like let's say a child of someone who is here as a worker could apply and get a visitor record that is the same length of time as their parent, right? Or same for a spouse, or an elderly parent who's here could have a long-term visitor record. And that visitor record could be 2-3 years, whatever, and has a clear expiry date. But it turns out that if you leave Canada, that visitor record becomes invalid. And when you come back, the clock starts running again. So you would be permitted to remain for 6 months. And if you want to stay beyond that 6 months, you can't rely on that visitor record that has now been, invalidated by you traveling outside Canada. You would have to apply for a new visitor record. This is one to watch out for, because you might think you got your client's child, for example, visitor record for 2-3 years, but if they have traveled outside and come back, they would have invalidated it, and you need to apply for new visitor records for them or study permits, depending on their circumstances. Otherwise, they're going to be out of status. If they're out of status for a long period of time, then you'll have to apply for TRPs. It's just a huge mess. Keep that in mind, again, because they're looking for ways of making people leave Canada, finding them to be out of status. This is going to be something that is going to be a sneaky one that's going to come sort of creep into some of those applications you work on. Okay, Nasreen?
Yes, I have a question for JR. Actually, one of my clients, I applied for JR. Actually, the court accepted her case, said that, okay, it should be reopened. But after 3 months, it actually, I got the report in October, but the application has not reopened yet. What should I do in this case?
It has been very clear that there's no system at IRCC for tracking these and making sure that they're open within a reasonable time. Some of them are and some of them aren't, but there's actually some recent ATIPs that showed there are cases that fall through the cracks, and IRCC knows this is happening. So what I would do in all of these circumstances, if it's more than 6 weeks since an application settled in court, like a month and a half, 2 months, then start doing web forms, do follow-ups so that they know and it gets on their radar. If you know, you should know what the visa office is based on the the refusal notes that you would have got as part of the court
Yes.
process. So, for example, if it's Ankara, you could write to Ankara. It's a little bit more complicated if it's a CN, the centralized network, they don't have an email address. But in any case, lots of web forms to get it on their radar. And it's still not very long. I know it feels very long for the clients particularly, but we do have circumstances where it does get to be, a year and they haven't had a result.
Wow.
That would be a situation where we could discuss mandamus, but until it gets to that point, that's not really a wise way to proceed. Web forms and follow-ups would be what I would do.
Okay, actually, I just submitted a few web form, but it still is not working. But is it a good idea if if I submit a new application or no, just I should wait?
I don't think a new application will necessarily work. Sometimes there's these random things that happen on the IRCC backend. I don't understand that a new application is maybe approved, but for the most part, the way that the technology works is that they will see that, when they run the new application UCI through their system, they'll see that there's an application in process. And so they'll keep the new application on hold until that prior application is finalized. That happens in 95% of cases. If you do submit a new application, you obviously talk to the client about it, but put very clear explanations that, this application is pretty much the same thing as what has already been submitted, but I'm submitting it because there's no movement on the prior application, and you provide a clear history of what's happened on that other application. They can easily access the file number and verify it, but if it doesn't get automatically refused and somebody reads it, then that's great. Again, I think on 95% of cases, a lot of the second applications get automatic decisions.
Okay, thank you.
No problem. Behruz?
Yes, so I have this question on visitors, but it's not exactly directly to this topic. Can I ask it?
Sure, let's see what it is.
Okay, thanks. There is this couple with the adult child that had two 5 years visitor visa, and now we're at the end of the second term of the 5 years visitor visa. They came to Canada maybe 4 or 5 times over these 10 years, but last time they came 6-7 months ago, and this child, which is now 24 years old, applied to become a refugee in Canada. Now, these parents want to get another visitor visa. Should I indicate that the child has been refugee here, because I can the portal actually not download the family information and don't tell them that where the status of the child is, or this is a misstep I have to tell them, or if you have to tell them, is it negatively affect their application?
Okay. So you can only apply for a visitor visa for them when they leave Canada.
Correct.
You can't apply for while they're still here.
Correct.
And in the application, obviously, you're going to provide the child's name. You're going to have the child's address, which is clearly that the child is in Canada. Whether you have to explain that the child is a refugee claimant or not, I think that's a bit more of a gray area. It is certainly something that they easily can verify. I've seen that in refusal notes where they have, they look up who the inviter is or who the family members are. That's part of their standard procedure. And if they find that that person is a refugee claimant, is an approved refugee claimant, and so on, I have seen that noted. Now, technically, it shouldn't be the determining factor, but oftentimes what happens is that it does impact their decision making, and a lot of times the applications are refused. The weight that's given to the family member who is a refugee claimant becomes less, I think, over time, if they become established here compared to if they recently become a refugee claimant. And one thing that definitely works in their favor is their own positive travel history of having gone back to, their home country numerous times and never having overstayed in Canada. So if you did do an application, you would want to really emphasize their travel history and also their ties to their home country through their work, through other family, maybe through other children. But that aspect of the child having submitted a refugee application, it is what it is. It doesn't necessarily ask you what the status of that child is in Canada. So don't necessarily have to include it. I mean, we actually have had circumstances where we have disclosed very clearly because we were providing identity documents for the person who is doing the invitation. So I can think of one recent example where the applicant was an accepted refugee claimant and was inviting his family members, like his wife and child, and we provided clear evidence of that. And that case is still in process. So at the end of the day, the fact that he has a refugee claim, it will be taken into consideration. But what you're trying to try and do is emphasize to the extent possible that they have ties to their home country and their only intent is just to come visit their son and go back.
Well, the point is the previous time that they applied, they didn't have the invitation letter from this person because this person just applied for refugee status.
Yeah.
So they had refugee. Okay, so if they get a invitation letter from the same person, if it was anyone, or maybe they booked the hotel, I'm not sure at that time, but let's say there was someone else give them the invitation letter. And now, if I submit the family information, where else they asking for the child status? These are a couple, and if you don't even name the child wouldn't be in the system. But if I do this, am I basically misrepresent because I know
That's a really good question.
Yes.
I'm going to save that question for the end of the presentation because I'm
Okay.
going to be talking about administrative monetary penalties that are going to be coming. And that does cause a question in terms of, you know, how do we advise our clients? Because if they do come, I'm not sure if this gets to the level of misrepresentation if you just don't include it, but it would certainly be in certain other circumstances where your client's asking, you know, there's adverse information that they want to not include, and you advise them how could that impact you and create liability for you. So I'm going to come back and discuss that when we get to that point. Okay,
Okay, thanks.
no problem. One more question, Dan? Dan?
Yeah, hi.
Hi.
I have some confusion about the validity of the visitor record.
Yeah.
One of our clients, an American, crossed the border on the visitor record, and I told her that it doesn't apply once you leave the country.
Mhm.
But when she came back,
Mhm.
they told her, no, your consultant doesn't know what he's talking about. It does apply.
Okay.
So I asked Tabitha this question, and she said there are two schools of thought. So I don't understand which one applies.
You know, I get that, and unfortunately, whether it's CBSA, IRCC, ESDC, they're always telling our clients your representative doesn't know what they're talking about, and I've had that happen in all kinds of circumstances. They just love to, you know, do that. But putting that aside, you know, if my client was in that situation where they had a valid visitor record and made this mistake, or like they left Canada, came back, and it was in this situation, I would try and make the argument, right? But if I'm advising my client about the validity of it, I would tell them, don't risk it. It's $100. Let's apply for a new visitor record. As opposed to you finding out, you know, in a year's time that the officer that's looking at your application is of the other school of thought and thinks that it's not valid. I have gone back, I don't remember it exactly now, but I have gone back and I looked, I think it was like, I want to say in regulation 183, where it's talking about temporary resident status, it does talk about this. It's not 100% clear, but it does talk about your status is valid as long as you stay here. And so again, you know, I would probably, if I had a situation where someone came to me and was found to be offside, I would try and make that argument. But particularly in the current climate, if I'm advising someone, I'm trying to be way more cautious, and I would say, don't risk it.
Well, yeah, this was a spousal application, and she kind of second guessed me, and she started like, her attitude was changing, like, you don't know what you're talking about. And I said, it's always been that when you leave Canada, your VR expires. That's the way I understand it.
Mhm.
And then she said, no, the CBSA officer says that the old one is valid for 1 year. So I said, okay, then, like, I just want to know for myself, what are we supposed to tell clients?
I would advise my clients that it is invalid if you leave Canada.
That's
And
what I thought.
if you got a different officer that said no, it's not, then you're going to be facing, an overstay situation.
Yeah. Okay. Thanks.
No problem.
Okay.
We can take a quick break now. We're at 4:06, and then we'll come back and I will talk about changes on the work permits and also on the PRs. Is that good?
John, we have two guests
Okay.
right now. If you agree, we can start continuing in 30 minutes, if it's
Sure.
okay by you.
So at 4:35?
4:35.
Sure.
Thank you very much.
Okay. Should I stop? Oh, you did that. Okay, perfect. I'm going to stop.
I'm not sure, Patrick, you are here. Do you have anything to present? So,
Yeah, sorry. So you're ready for me now?
Zainab John, is it possible that you stop sharing your presentation? Thank you very much. So, thank you very much. We have two guests today. Patrick Macaron from Prometric, which is provider of CELPIP and CAL exams, and also Surush from Ilya English Academy.
Academy, right.
Great. So Patrick is a stakeholder relation specialist and business development at Prometric, and a great friend of me. Floor is yours, Patrick, if you wanna.
Thanks so much, Ali Reza. So, hi everybody. I'm happy to be here today. I'm just going to keep it brief. I have a little presentation on CELPIP, which is one of the English tests. I'm sure you all are familiar with it. So, just going to share my slides right now. Just give me a second. And hopefully everybody's keeping warm. I know it's pretty cold today, right now in Toronto. I'm in Toronto. Surush is in Vancouver. So he's got the good weather and I got the crappy weather, basically.
Right.
All right. So yeah, feel free to ask me questions. We're also going to have a Q&A period right after I'm done presenting. So you can ask any questions you have about the test. But yeah, I'm here today to talk about CELPIP. So Prometric is the company that I work for. That's the company that owns the CELPIP test. So, but everybody, all the test takers know about the test name, which is CELPIP. Very thankful to Ali Reza for giving me this opportunity to share this information with all of you. Ravidid Immigration Services is an official CELPIP partner. And Ali Reza and I have become good friends throughout the process. So, but they are an official preparation provider of CELPIP. So Ali Reza is going to be talking a little bit later on about the prep classes that he offers to test takers that want to prepare for the exam alongside a CELPIP teacher. So as of right now, we're pretty available worldwide. So we have a lot of testing centers, both in Canada and internationally. So as of right now, these are the current countries where you can take the CELPIP test in. So if you have any clients in any of these countries that want to move to Canada, or any clients that are able to travel to any of these countries, then they can take the CELPIP test. And we are rapidly growing. So every month we're opening pretty much in a new country. So you can check our Instagram channel, our website. That's where we post news of new countries that we've opened up in. I know that perhaps a lot of your clients might be in Iran. So unfortunately, we don't test in Iran right now. I wish I could say that we do. But we do have neighboring countries where your clients can take a CELPIP test. So they can take it, for example, in Kuwait or Saudi Arabia or Qatar or Dubai. So we do have neighboring test centers. So hopefully that's a little convenient for them. But yeah, right now we don't test in Iran as of right now. So just a little spiel about like the features of CELPIP that makes it different from other English tests that are out there. CELPIP is Canadian. It was developed in Canada. So when a newcomer is doing the listening test, they're going to be listening to a Canadian accent. It's not going to be like a British accent or an Irish accent. CELPIP only uses Canadian accents in the listening test. The full test is 3 hours. So you actually complete the entire test within 3 hours. So if you finish the test actually in 2 hours, then it's only a 2-hour test for you. So, but the maximum time that you're given is 3 hours. The good thing about CELPIP is that you do the full test within that 3 hours. So you don't have to come back later that day or take another day off of work to do like a separate speaking interview. You complete speaking at the same time as the other components. So it's all done in one sitting in 3 hours. The results come out in 3 to 4 days. So they're fairly quick, and the newcomer will have to sign into their CELPIP account. So they'll have to go to the CELPIP website, sign in, and then they can view their digital score report. So they can actually download this score report onto their computer, and then they can submit it online to the Government of Canada. So that's the current way that they would get their scores and then submit them. It's all done online. We have free study products. We also have paid study products. But Ali Reza is going to be talking about the great prep classes that they have, because a lot of students are looking for kind of guided preparation where someone else is helping them, giving them feedback. So Ali Reza has CELPIP certified instructors that can train you virtually on how to do well on the CELPIP test. So they'll be talking about that shortly. So we have 2 tests. We have the CELPIP General, which is the test at the top that covers listening, reading, writing, and speaking. In Canada, it's 290 plus tax. If you're taking the test in other countries, the price will vary a little bit. The CELPIP LS is for those that are applying for citizenship. So that only tests you in listening and speaking. And that's because that's the case. It's only about an hour long for the CELPIP LS, and it's a lot cheaper. So it's 195 plus tax. So so we do have a CELPIP test for immigration purposes and a CELPIP test for citizenship. CELPIP is accepted for the post-graduation work permit. Our test centers right now are like pretty much full to the brim because a lot of newcomers right now are taking the test in Canada for their PGWP application. So it is accepted, CELPIP. When they're registering online, they would just, it's going to ask them, what is the reason why you're taking CELPIP? So you just have to select for permanent residency, temporary residence in Canada. So that's what you would select on the CELPIP website when you're registering for a test for PGWP purposes. CELPIP is accepted by a lot of professional organizations. So like if you want to become a licensed medical professional in a province or a licensed real estate agent, a lot of these regulatory bodies will mandate that you prove your English or your French ability. So CELPIP is accepted by a lot of these professional associations. So a newcomer can take the test for their PR, but they can also use those same results to become a licensed professional in their career path in Canada. So, went back instead of forward. We do have a current promotion. It's a partnership that we have with National Bank of Canada. So right now, there's a link that they can go to, but if a newcomer opens a bank account with National Bank, they have to do a few things, like they have to set up direct deposit for that account, and they would be opening a checking account. But once they do that, they will get $300 cash back deposited into their account. And that money, for example, could go towards paying for the cost of their CELPIP test. So it is a special, unique promotion that we have with National Bank of Canada. And I can share that link with all of you. So I believe that the newcomer has to have been here 5 years or less. They can open the account from home, and they can also activate the account from home if they're in Canada. And then the $300 will get deposited. I think it's within 3 to 6 months from the time that they've completed the criteria. But for the most part, it's just open the bank account, set up direct deposits from your work, and then that's pretty much what you have to do to get that cash back. So you can share this with your clients. It is available right now. So and we know that newcomers' lives are very expensive, especially when they first come to Canada. So this can kind of help a little bit with that. So just briefly, CELPIP scoring, it's out of 12. So they're going to get an individual level in each component. There is an average score as well that they'll get on the score report, but IRCC doesn't look at the average score. They only look at the level someone got in each section. So typically you'll have to meet like a minimum score to qualify for PR or PGWP, things like that. We do have a network. So if you want to become an official agent partner of CELPIP, you'll get things like a business account. You'll get access to our logos if you want to put that on your website. Your firm will be listed on our website as an official partner. So any client that's on the CELPIP website that's looking for immigration help, they're going to see your company listing on the website to click on your name, go to your website, and contact you for immigration assistance. So there is other benefits as well, but it is a free partnership program. So you can apply. It's totally free. You can still work with other companies. It's not exclusive, but you do get those benefits. You can register clients for the test yourself. You can have like an affiliate banner you can put on your website. Clients can click on it, register for the test. So you have different tools available. And you can go to celpip.ca/network to apply to become an official immigration agent partner of the test. We have a lot of free resources newcomers can access to prepare. So we have free practice tests. We have a YouTube channel, which has tons of lessons that they can watch on demand to prepare. So they can go to celpip.ca/free. That's pretty much for the self-study options. We also have an online store where you can buy digital study products like practice tests, online study programs, things like that. And then we have preparation services. So Ravidit Immigration Services, Ali Reza's company, is an official CELPIP preparation provider. So oftentimes to get the upper hand, clients need to consult with a prep provider to find out, what their weaknesses are, how they can work on them. So we do really recommend that anyone that needs to get especially a high score in CELPIP does take an online preparation program. So I'll just get Ali Reza right now to talk about his prep classes that he offers.
Thank you, Patrick. I didn't know that you will add my website on your presentation, and I was surprised. As Patrick mentioned, we started as a CELPIP network member, and we registered our clients for CELPIP exams and CAILA exams. After a while, my team expanded. I had 4 CELPIP an English instructor, so I registered them with Prometric, and they trained them. They receive right now level 2 of CELPIP. They are certified instructor. Plus, I have one instructor who is located in Iran. We don't have CELPIP test in Iran, but we can train Iranian if they want. Uh, as a regulated Canadian immigration consultant, we all know that what our clients need, in which CLB level of English they should be to have more points for immigration, in which level they should be for postgraduate work permit right now. So if you use any CELPIP provider services, you can coach better your clients, because the trained CELPIP instructor can improve any skill that your client needs to be improved. For example, maybe they receive CLB5 because they're writing. So we can focus just on their writing and go 2 or 3 levels higher than they are at the moment. You see on our website also we added some great points if anyone wants to use CELPIP instead of IELTS. What can I add it?
Yeah, that was great. Yeah. Awesome. Thanks, Ali Reza. All right. So yeah, just pretty much wrapping up here. But oh yeah, as you guys know, there's a lot of scams in the immigration sector. There's a lot of people on social media like Instagram that are telling newcomers, if you just pay me a certain amount of money, I can give you a score report so you don't have to take the test. So yeah, so we're trying to shut these providers down whenever we see them, but they are out there. So we try to alert test takers just to know how to spot that and to not get involved and take the test legitimately, get your legitimate scores so that you don't run into problems with your immigration process. Our YouTube channel, Instagram channel is a great way to stay up to date with CELPIP. So I would recommend you or your clients could follow us on Instagram. Our ID is CELPIP Test Official. And we're always posting updates like new locations we've opened test centers in, when we have discounts on our study products, free webinars. So it's a great way to stay informed about the CELPIP test. All right, so now we'll turn it over to the Q&A period. If anybody has any questions, we'd be happy to answer them.
Arbel, I think you have a question.
Yeah, hi. Okay, my question is, do you have possibility to offer franchise, like for us to have a CELPIP test center in international countries?
Typically, so you can apply to become a test center. Typically, it's got to be somebody that's not practicing immigration consulting. So we have like a conflict of interest policy. So it would have to be somebody that's not an immigration consultant that's applying to become a test center. But yes, we look for schools, universities, private companies that have computer labs to apply to become our new test centers.
Okay, can we discuss the requirement like later on, like on private?
Sure. Yeah. This is my contact information right here. You have my cell, my email. So feel free to get in touch with me and we can talk more about that. Definitely.
Okay, thank you.
Yep, my pleasure.
One more question. I noticed that you have a center in Lebanon, so I'm planning to do this in Lebanon. Like, is there any exclusivity for these people, or we can still have room for another center?
No, I think we can still have room for another center. So definitely we can chat more about that. But Lebanon is a good area for us, so for sure we could have another center there.
Okay, sure. Thank you.
Yep, no worries.
Excuse me, Patrick. Hi. This
Hi.
is Ario. I'm sorry I couldn't find my raise hand button, so I
okay.
guess I'm just gonna jump in. So for if somebody's interested to become a test center, let's say in Richmond Hill, Ontario, like
Yes.
and so your first requirement that they would not be practicing immigration consultant, right?
Yeah, it would have to be someone that isn't licensed with any kind of immigration consulting body.
Okay, so so let's say for instance, like if someone was to approach you as an immigration consultant, so they have to basically give up their license to become your agent?
Yeah, I would say more along the lines of like if you know somebody like a friend that has their own separate company, they could apply to become a
Yeah,
test center.
absolutely, absolutely.
Yeah, I think like if you quit being an RCIC to open a test center, like it might be a flag for us if we knew that.
Absolutely. No,
Yeah,
I understand. I know
just
because
yeah.
sorry, because I don't know if that would also goes under the conflict of interest or not.
Mhm.
My firm of recently joined with another company. They're called Abrodeen.
Okay.
Abrodeen, they're like a platform that does we have a contract with over 100 colleges and universities in US and Canada, Europe, England, everywhere. And basically, it's a
Awesome.
platform that joins the prospective international students
Mhm.
to their colleges. And also, like, there are people behind the scenes that obviously do the paperwork.
Yeah.
So we're doing this. So my question is, like, if we wanted to, let's say, start advertising or offering CELPIP services on our platform, would
Mhm.
that be like, like I believe Applied Board has an IELTS link in there. So
Yeah.
we want to do something similarly. Would that be something that would interest you guys, or?
Yeah, we sell oftentimes we've sold like test vouchers on Applied Board. So we
Yes.
sell them like discounted test vouchers so people
Yes,
can pay for CELPIP like 10% off on Applied Board or something.
absolutely.
So definitely we'd be interested in looking at other providers like that. Yeah, for sure.
Okay, so I guess
Shoot me an email or text me and we can talk more.
absolutely, yeah, absolutely. That would be perfect. Thank you very
Great.
much.
My pleasure.
Thank you.
And we have Sarush is also an instructor. So if you have any questions that you wanted to ask him, he's probably more knowledgeable in CELPIP than I am. So
Okay, and to have like let's say a CELPIP center,
Mhm.
do you need to have like certified instructors in there or not? Just out of curiosity, because
like a test center or a prep
yes,
center?
a test center.
Test center, no. You would just have regular staff that would be supervising the testing as it's happening.
Okay.
But no, they don't have to be instructors. No.
Yes. Yes. All right. No, because I did Kale many years ago to become a
Okay.
immigration consultant.
Yes.
So I have no idea about how these test centers work, or
Oh,
never done
yeah.
it before. Yeah.
Yeah.
So okay. Thank you very
No
much for
worries.
your explanations.
My pleasure. We'll be in touch.
Thank you. Absolutely.
Yeah, hi, Patrick. Thank you so
Hi.
much for joining us.
My pleasure.
I would like to know if colleges and university accept CELPIP as a profession, English knowledge proficiency. They do accept CELPIP?
Colleges and typically for that, so there's two things to that. So CELPIP right now is our general test. CALE is our academic test. So that's the test that has all the
Okay.
university acceptance. But what we're going to do this year is we're going to try to get CELPIP also accepted by the universities. So they already accept CALE.
Okay.
But since CELPIP seems to be more popular and people trust CELPIP more than CALE, we're
Right.
trying to get CELPIP now accepted by the institution. So right now they don't, but
Okay.
I'm sure they will be on board because it is accepted by the government and things like that. So
Right.
Yeah.
And Kale is offered right now by other international branches you have in other countries?
Yeah,
This
we
one
have it
is
in
only-
other countries,
Yeah.
like South America, I think Dubai. And you can take Kale at the test center on a computer or from home on a laptop or computer. So it is a computer-based test, but you can take it from home or at the test center. And
Okay.
all the institutions in Canada accept Kale.
Thank you so much.
My pleasure. These are all great questions. Sarush, did you want to say anything about maybe your classes that you're running with CELPIP or
All right. Hi everyone. Adirsajan, thank you for having me today, and thank you so much, everyone. Patrick, thank you so much for all the explanation. If I can, I would like to introduce myself and all about my school. I'm Sarush Azani, and I have the privilege of serving as the founder and owner of ILA English Academy. We are a Vancouver-based online school, and what we do is that we actually offer, we are a school for CELPIP, IELTS, ESL, French, and Spanish with around 30 years of professional background, currently delivering courses to students from all around the world. Our instructors are located in Vancouver, Toronto, Montreal, Calgary, and as far as Costa Rica, because we have a Spanish teacher and she gets connected from Costa Rica. We are also proud to be a CELPIP official network member and an approved center in Canada, offering both training classes and mock tests to all the applicants. And the things which I think make us different, we've got a team of CELPIP certified instructors, around 15 teachers all around Canada, each with at least 15 years of experience. And we are very fast paced, without actually, I mean, our fees are really reasonable. We are all about fast paced learning, let's say, without breaking the bank. And our classes are designed to get you and all the students where they need to be. And yeah, we have all these courses, and we are in Vancouver. We do online classes. We get students from all around the world.
Yeah, it's Sarush is a CELPIP guru, as is Ali Reza. So yeah, they can help if you have any clients that want preparation support for CELPIP or Kale.
Yeah.
But yeah, that concludes my presentation. So any final questions?
Yeah. Okay. So is it online or in person, and how much you're charging? Is it per hour or there's set hours or?
So Charbel, if I'm pronouncing your name
Yes.
correctly, right? Yeah, we just deliver online classes. We used to be downtown Vancouver before COVID hit, but as of March 2020, so I mean we closed the downtown office and everything is being delivered online. There is a management office in North Vancouver in Lynn Valley, but all the teachers, as I mentioned a few minutes ago, they are all in different parts of Canada. And we just deliver online classes.
Okay, and then how much you charge and how many hours needed?
It all depends on, the number of classes they need. You see, we have a full package of class. For our CELPIP, it's a 40 session package. It's our group classes, but some students may not need the whole package. So we do consultation with them at the beginning, or we give them mock test, or if they have already taken the test, based on the scores that they have received before, they share the scores with us, and then we tell them how many sessions they're going to need. So we basically customize the course for our students. Maybe a student needs like 10 sessions of private classes, like the whole package for 40 sessions in the group classes. But like it ranges from I mean, for our group classes, we charge $45 per 90-minute sessions. So $45 for 90 minutes and $80 for the private class, again, 90 minutes. But when they get a package from us, the final fee may vary. Yes, and then so we make a good package and reasonable and affordable package for them. But that's all we all do.
I have a client like he's interested. He needs everything like so if you need 24 hours, let's say 6 hours each, like writing, reading, whatever, like each category. So how much would you charge for something like this?
If you allow me, Sharbel, I can share Surush and Patrick's email.
Sure.
You can continue after this TPD
that's
session.
right.
We are running at the time, and I know that Zainab is ready to continue her presentation.
Thank you very much for your time.
Thank you. It
Thanks
was
for this
great to meet
opportunity.
you both here. Thank you for sharing your information.
Thank
All right,
you.
thanks everybody.
Thank
Have
you.
a great afternoon.
Yeah.
Thank you. You too, Ahmed.
Thank you very much. Thank
Thanks.
you.
Take care.
And
Bye-bye.
before continuing, Arjujan, would you please write your name and RCHC number on the chat? I don't have your name. Thank you. Zainabjan, apologize for delay.
No problem. That was wonderful. Okay, are we recording? Yes, we are. We didn't stop.
Yes, I
recording?
forgot
Perfect.
to stop recording.
Okay,
by
that's
the way.
perfect. Okay, I just want to make sure we're not going to miss stuff for anyone who's listening in later, because we're getting to even more fun parts. Maybe talking about changes, still in the temporary side, but we're now talking about work permits. So we have seen a lot of changes take place in the LMIA processing. So I'm going to go through that first. We had, starting in September, changes to the low wage stream. And we also had the coming into effect of a higher threshold for applicants that will, applications that are going to fall under the high wage. So the high wage, if anything is at the high wage level or above, it will be considered and continues to be processed. But if it's below that, it's considered low wage. And so you can see on the chart that I put on the right, those figures have gone up significantly. So for example, in Ontario, if it was below $28.39, the prevailing wage for the occupation, it would be considered low wage. Now it's $34. British Columbia, sort of similar as well. So that's just important to keep in mind. A lot more jobs are actually falling under the low wage. And we're also seeing that if the position being offered is low wage and falls inside a metropolitan area that has 6% unemployment or higher, then ESTC Service Canada is not going to process the low wage LMI application. Now, one thing you want to do is, I believe every quarter they go back and they update the unemployment rate. So from the time that this was initially published until now, there's been at least one publication where some areas that were previously 6% or more unemployment are now less. So again, this would be something that you want to take a look at anytime that you have a new application that you're potentially working on, to make sure that does it fall under this restriction and refusal to process, or it doesn't. There are some limited exemptions for low wage positions that they're still allowing to proceed irrespective of this. But generally speaking, the idea is to try and reduce again the number of new potential applicants. And the changes also brought into effect meant that low wage LMIAs are now issued for a maximum of 1 year. And the validity of LMIAs have also been reduced. So for a period of time, we had LMIAs valid for like a year, and now they're back down to 6 months, and they have to submit applications within 6 months. Not exactly on point, but it's sort of related here. I have reached out on the group chat to also ask about this, but over the last couple of weeks, I've seen a lot of people who've already submitted low-wage LMIA work permit applications, their work permit applications have in fact been refused. We've seen a spike in that over the last few weeks. If you've had situations like that, reach out to me. It might be that they're trying to clear out their inventory and are not really assessing the applications, and they know it's extremely difficult or actually impossible for these applicants to go back and get a new LMIA, because by now their LMIAs are, expired and the new ones are not going to be processed. So for many of those, their only opportunity might be to do some kind of litigation or group litigation. So if you do have a situation like that, please reach out to me.
Sorry, what's the situation?
So over the last few weeks, we've seen a lot of applicants who have work permit applications that were in process that were low wage positions. So bakers, cooks, butchers, admin assistants, things like that. Valid LMIAs provided evidence of their ability to do the job, language, and other things, and they're being refused. We've seen several of them. It's very early on, so we're trying to gather information and get officers' notes, but it does seem to be a bit of a trend. And anytime we see this, it often coincides with where they're trying to clean up their inventory. So instead of actually reviewing applications, they refuse them en masse, and then they're like, some of these people will go back and try and maybe JR it or figure out what the problem is, and we'll deal with that when it comes. But in the meantime, we've reduced our application inventories, and we've increased the refusal rate, which is what they're trying to show drastically to the US, that we are a high refusal area. So that's what I'm talking about.
I can give you a weird scenario. My client is applying for a cook. They ask him for IELTS.
That's one of the things they are consistently doing, making sure everybody has language. If they don't, they have to have other proof to demonstrate that they have the required language ability. I've actually had something very stupid. It was on a high wage LMIA, not a low wage LMIA. The LMIA was valid when it was submitted, and we had the visa office come back to us a couple of weeks ago and be like, submit an updated LMIA. And we're like, did you read the application? Like, what's going on? At least it wasn't refused, but it's showing me that they're not really paying attention when they're doing these, certainly. Okay. Something else that really came to focus last year, and you want to be mindful of now, is what's called concurrent processing for work permit. So in some situations, you might be applying for your client's work permit extension, but the LMI has not been issued yet. And previously, if that was the case, you would explain it in the work permit application, and IRCC would keep the application on hold until you would provide the LMIA. Last year, they came out and said they will do this only for 60 days. They'll hold the work permit application on hold for 60 days. And if they receive an LMIA, then they'll proceed. If they don't, then they will refuse the work permit application. 60 days is pretty arbitrary, because we all know that other than, maybe the Global Talent Stream, none of the other LMIA application streams are processed that quickly. But in any case, that's something to be mindful of, because it's a change in their policy. They used to do this, but they don't do it anymore. And in order to even qualify, you'd have to sort of wait until right at the end where the work permit's about to expire. So 2 weeks or less until the expiry of the work permit, and proof that the LMIA has actually been applied for. So you would have, maybe the LMIA application number, because it's all online applications now as well.
So
Okay.
what happened if refused? Like, this LMIA is still in process and it's refused within the 2 months. What should suggest?
It depends. I mean, if there's a restoration opportunity, then and the LMIA is issued within the 90 days, I think there's a case to be made that you could try restoration. Otherwise, your client might be out of luck and have to leave Canada if they're and then apply for the work permit once from outside of Canada once the LMIA is actually approved. It is, again, pushing out as many people as possible, and as soon as your application is refused, you have to stop working, right? So that's going to be detrimental for Canadian businesses, particularly those that are relying on specialized knowledge workers and so on. Dan? Dan?
Yeah, hi, sorry about that. Very weird situation. We have a girl who's not even our client yet. She just made a dummy work permit with an LMIA in process. She did it all herself, and guess what? They approved it. I can't believe it. They approved a work permit without an LMIA. She's confused, and now she wants me to wants our opinion on whether she should actually continue working.
Well,
I don't know what to say. So
technically,
basically,
that's almost a misrepresentation,
well,
right?
that's why I didn't want to. So
Yeah.
hear me out. So basically, she hasn't received the paper permit. She hasn't received the paper work permit. So we don't even know if this is a closed work permit or not. She's assuming it's a closed work permit. She's just received the email confirmation. I've never heard of this happening.
They don't send
I mean,
email confirmations. They
you know what I mean is
on
that,
the online account it says your application.
yeah, the online account saying that you've been approved
Mhm.
and the validity period is for 18 months.
Mhm.
I'm assuming it's probably an open permit under some extension, and she doesn't know what she's got. And so she was asking us, and I said, this is very strange. Like, it's never happened, but
I would
I
wait
don't know
till
what.
that document comes and actually see and do an ATIP as well, just to try and figure out. Sometimes it's interesting to do ATIPs even when you have a success, because you're trying to understand what they're doing on that back end, right? And you
Yeah.
might see something that's really helpful. I would definitely try and get the notes on it and wait till it comes. But that's just like go buy a lottery ticket, that that kind of thing doesn't
Well,
usually happen.
honestly, if she continues working and plays dumb, how is this going to help her in case she wants to use that as an experience towards PR? They will definitely call it misrepresentation, right?
Yeah.
But the thing is, if she does it, I don't know. I don't know what to say, what to make of this. This
Well,
is so bizarre.
we're going to get to misrepresentation in a few minutes, and I have a lot to say about it, so I will save my comments till we get there. Is that okay? Okay.
Yeah. Thank
okay.
you.
So IMPs, there was big changes that came. There was a lot of little changes in the various instructions for different categories, but the big ones I think were with respect to intercompany transferees. So in a way, I welcome this because there's more clarity. And what we were already seeing is that this understanding of what the ICT was in the minds of officers, and they were using this kind of language to refuse applications anyway before these changes came into effect. Once these changes came into effect, it became crystal clear. If you submit an application now, this is the requirement, this is what you have to meet. And I think that is really good. As long as IRCC is clear in terms of what it wants and people can plan accordingly, can decide if they qualify or not, and it saves everybody a lot of headache. We were actually successful in overturning those refusals from pre-changes when this language was specifically published, and we said, well, look, this policy has just come into effect. You can't refuse applications when the policy wasn't even in effect. In any case, what does the policy change look like? It became very clear that for new businesses that are being set up in Canada, as in new branches, it would only be permitted if the branch was going to be from a multinational corporation. And to meet the multinational corporation definition, or the MNC definition, to apply under C61, it's very clear. The business has to have active operations and it has to generate revenue in at least 2 countries before it qualifies as an MNC, right? So basically, if they were only operating, let's say in Iran, in India, in China, wherever, and they were setting up their first international location in Canada, it was perfectly acceptable before, but now it's not the case anymore. It can't be that your second operations is going to be in Canada. Essentially, your third operations can be here. You already have to be multinational before you start operating in Canada. And in order to qualify under C61. And it's very clear they want evidence that you're actually operating. So they have a lot of details in terms of documents you can provide, contracts, lease agreements, employees, when it's talking about revenue generation, they're talking about taxes, bank statements, and so on, and obviously incorporations and all the other formal documents that show operations in those places as well. So that was a helpful clarification. I think it was important that they finally did that because they were already trying to use this kind of thing. The other clarification that came is that they clearly said that in order for executives and high-level managers to be hired, so for the occupation codes and the higher occupation codes, the business that's being set up must have the occupational capacity, right? So the organizational chart has to make sense. If you're going to be hiring 3 people in Canada, it probably doesn't make sense to have a senior executive compared to if it's going to be 20 people, 50 people, and so on that's going to be hired in Canada. This is something that officers are now instructed to look at very carefully. And as I said, they're looking for very detailed documents and evidence that wasn't necessarily the case. I mean, I think a lot of people that were already submitting these applications included things like business plan and proof of funds, but now it's very clear they want to see detailed business plans and financial projections, staffing plans, and then evidence of financial capacity of both, the parent companies or the affiliate companies outside of Canada, where those funds are going to come from and so. And because the C61s are intended to be for startup businesses, not startup visa, but startup as in like new operations in Canada, the idea is that these are going to be 1-year work permits as opposed to C62 and C63 that can be 2 or 3-year work permits. And at the time of an extension, the goal is that the applicants have set up a business up to a point that they're now switching to a C62 or a C63. And in some exceptional situations, it might be the case that they might extend a C61, but for the most part, they will want to see enough establishment that the business is able to provide a lot of documents in Canada, tax returns, income documents, personnel, and so on, to now be able to qualify as C62 or C63. The other program that saw a lot of changes, work permits for startup visa. It came into effect finally in October 2024, but it was actually announced the prior summer when we still had Minister Fraser, and he said we're going to get open work permits for startup visa applicants. And it came in, sort of under the radar. They just put it in there that now you can apply for these optional work permits. The A77 IMP exemption code is still in the system. That was what was used previously for the closed work permits. And I had a very interesting consultation where somebody was potentially thinking of still applying for a closed work permit, even though it is possible to apply for the open. And we had a conversation of what that might look like. But I think for the most part, many of the applicants are going to be trying to apply for the open work permits. But just because it's an open work permit doesn't mean that they don't have to meet strict eligibility requirements, and there's a lot of detail now on the website. Again, this is something that I welcome in terms of what officers want to see. They want to see business plans, they want to see progress reports, staffing plans, if they've done exploratory research and so on. As with any other work permit application, they want to see the ability of the applicant to do the work that they're going to do in Canada. So if it's exactly the same, then that's really helpful compared to what they've done before. But if it's a different position or a different set of skills, you have to be able to demonstrate how they're going to be able to do that, right? So resumes, work documents, education documents, courses, and so on, those are all very helpful. And then the other important one is financial capacity. It's the LICO, so essentially they're going to be able to cover their own living expenses. But in addition to that, investment funds for the business. This came into effect actually the prior year when they made the A77 regulations clearer. The investment funds will depend on the business type and what stage they're at. But if their business plan says that they require $200,000, $100,000, however much it is, they have to be able to demonstrate that they have that or have access to it, and it's if they've already invested part of it and so on. This is extremely important. I've seen refusals based exactly on these grounds, and if they don't provide this, then they're going to be refused. And this was in the regulations before, so it's not a change, but they do have to demonstrate they've already submitted their permanent residence applications along with anybody else who's essential in their business. It's not possible anymore to be able to submit a work permit application before you do your PR application under this category. Okay, moving on to permanent residency programs. There's so much happening, and it's become extremely difficult to advise clients. And we've talked about the temporary staff up to now, but most of the applicants who are here on a temporary basis, these are the questions they want to know. They want to know how they can apply for permanent residency. And I set out right at the beginning of the presentation that we have all of these lower numbers, so essentially what I call caps for many of the programs, and we're already seeing the impact of these in terms of longer processing time. So the inside of Canada is an example. Inside of Canada spousal work permit, inside of Canada spousal sponsorship applications now are posted at 24 months. That's gone up from what it used to be before, around 12 months. We look at things like the Quebec Business Investor class, it's posted at 71 months. Like, these are extremely long. I think we're going to probably see some of the other PMPs and express entry, etc., also see longer processing times, maybe less on express entry because they control it more through the number of people that they invite, but particularly on all the other categories that they don't have as much control on the number of entries, we're going to see longer and longer processing times. They announced almost a year ago that there was going to be a new caregiver program once the prior 5-year program finished in June. The program finished in June, and there's been no details that have been published in terms of what that new program looks like. Over the weekend, or maybe right on Friday, they made a small change on their website saying that the new program is coming in March 2025. I am not very confident that that's going to be a robust program. It's probably going to be highly oversubscribed, and it will not be, I know it's being sold as like, this is an opportunity for a lot of people to apply, but it's going to be a limited number program. I don't think we're going to see huge numbers in this, and the maximum capacity, if you go back to the levels plan and look at their breakdown, is about 8 or 10,000. So keep that in mind. It's something to watch out for. They said that it's coming. They've also made an announcement that there is not going to be a new grandparent intake for 2025. We'll have to see how that plans out, but as of now, there isn't going to be one. Sorry, just give me 1 second. Sorry about that. So no grandparent intake planned for 2025, and I can imagine that would be the case. Other big changes over at Express Entry, we did have category-based draws introduced in 2023, but in 2024, a big chunk of the draws that were done were category-based, and they were also French-based. So that kept the required CRS scores very high throughout the year for everybody else, making it extremely difficult for applicants to obtain ITAs. Again, this is the situation we're in. The latest big change, I think, on that one is the announcement they made at the end of the year that the job offer points are going to be eliminated. Now, keep in mind, in order to do that, they do need to go back and change the actual regulations and so on. And right now, the government is shut down. So even though they said this is going to happen in spring of 2025, it's very hard to advise clients of when that change is going to come into effect. It's hard to advise our clients who have the lower scores. It's hard to advise those that maybe have a job offer and sort of waiting to get to a 1 year of work experience in order to be able to either qualify for the job offer points or to be able to get the Canadian work experience points. In any case, this is something that will be on my radar. I'll be watching out for it, and it will have an impact, because if they do away with it, there concerns about, LMIA business in terms of fraudulent LMIAs and so on. But the 50/200 points that they would potentially eliminate will have a big impact on a lot of the applicants. And looking at the numbers over the last 2 or 3 years, a higher and higher proportion of applicants have had job offer points in the pool of those in the number of those who received ITAs. And so the elimination of these points will have an impact on what those scores are that received. Other really big changes that we saw were in the Startup Visa PR program. We had the introduction overnight, literally, of the caps on issuance of new commitment certificates by designated entities that kicked in at the end of April. And at the same time, there was this idea that certain applications are going to be prioritized. We'll have to see if that actually works out. I can't say I've really seen that in effect, because I, for example, have an applicant who is from one of the designated entity, the incubators that are part of the priority list, and despite follow-ups, there's been no faster processing for their application. What we're seeing in practice there is that they're also just looking for lots of excuses to refuse more and more applicants, as with other categories. They're going back, they're reviewing commitment certificates, particularly if there's been any changes in commitment certificates in terms of teams and so on. They're looking in detail at the term sheets and service agreements that the designated entities have provided. Unfortunately, we've been seeing a lot of increased procedural fairness letters and also refusals coming out of this program. There is a huge backlog of about, from what I recently read, about 20,000, maybe more applications. And given the small number of spots that are allocated for business immigration, we're going to go way beyond the 39 months processing probably for these. And we're probably going to continue to see high refusal rates of them trying to find reasons to refuse more of these applications as opposed to process them. We've seen the closing, at least for now, of the self-employed program. For the PNPs, we've also seen reduction in terms of their quotas, and also something that I've seen more of is for those who are trying to obtain work permits for the PNP programs, or even the Atlantic immigration program, we're seeing more refusals of those work permit applications. And there's been introduction of smaller pilot programs, but they, for the most part, are very specialized and end up filling up very quickly. Okay, citizenship, big change for that. We did have the decision that came out right at the end of 2023, which was with respect to the first generation limit. It was basically if you were a Canadian citizen who was born, if you were someone who was born outside of Canada to parents who were also born outside of Canada, they were Canadian, then you would not automatically be a Canadian. You would have to go through certain steps, and if you didn't, you would not be a Canadian citizen at all. And the Ontario Superior Court actually found that to be unconstitutional, and they gave the government time to put together essentially a mechanism for people to apply and be able to get proof of citizenship for those that fall under this. They were supposed to do it up until November, December. They didn't, and they asked for another extension until March 19th. So that's something that we're still waiting on. Yes, Charbel?
Case that the parents of a Canadian citizen were born overseas, and then they never claim citizenship. Now the grandchild, which is the son of these parents, he's interested to get it from his grandparents. Is this feasible?
So his grandparents were Canadian citizens.
Yeah. So his parents were born
but his parents were born outside of Canada.
But never claimed their citizenship also. Never claimed for it. Never applied for it.
They never applied for proof, but they are Canadian citizens.
But they never applied.
Yeah. So they just don't have any documents to prove it, but they are because their parents were Canadian citizens. But based on this first generation limit, these children that you now talk about, these grandchildren, would not be Canadian citizens, right? And so with the coming into effect of hopefully the mechanism for this, they should be able to apply and overcome this and be able to demonstrate that their parents were citizens because their grandparents were citizens, and therefore they should be considered citizens as well.
So the parents don't have to apply. Just if this goes into force, then the grandchildren will apply and say, these are my parents.
What they apply for is proof of citizenship. They're not applying for citizenship. It's not a grant of citizenship. You're just applying for evidence, essentially, that you are a citizen. And so, again, the parents are citizens, whether they want to or not, doesn't matter. Like in terms of definition, they fall into it. They don't have to apply to get the proof, but the children would provide, birth certificates for their grandparents to show they were citizens, probably born here, or if they were naturalized, their naturalization documents, and then they would provide their own birth certificates showing who their parents are, and so they'd be able to demonstrate that they are in fact Canadian by descent.
Okay, good enough.
Yeah.
I have a question about work permit, but should I do it at the end after you're done here?
Sorry, what was the question about?
About work permit, actually.
Let me go through, and then if we have
Yeah.
time, we'll go back to it again.
Okay,
Okay.
yeah.
I do want to get to some of the fun stuff here. How much time do we have? 15, 20 minutes, do we? Potentially? I know everyone's probably rushing to go.
15 if it works for you.
Okay, let's
Is it
do.
enough?
I think it should be. It should be. I'll try and keep it short and let people ask questions because these are important points. We've had the end of flag polling, which is very problematic because there's certain instances where it's very important, but it's also potentially good in some ways because a lot of people were falling into problems through flag polling and being found inadmissible, being given exclusion orders, not understanding flag polling was actually a refusal to enter the US, and then later being found to have misrepresented when they didn't declare their flag polling. So in any case, we no longer have flag polling, and there's actually a lot of interpretations around this from CBSA is that any travel from Canada to the US, whether it's for one day or a couple of days or a week, could be considered flag polling if you're going to be applying for a work permit or another permit on the way back in. And it seems to be the consensus that you have to go back to your country of residence or your country of citizenship in order for it to not be considered flag polling. So that's that. There has been an insane increase in misrepresentation findings and in investigations. For temporary resident applicants, those numbers have gone up a lot. In 2014, there was approximately 5,000 total misrepresentation findings for temporary resident applicants. That number has gone up to 52,000 in the last year. Okay, and as I showed you at the beginning, we were looking at misrepresentation investigations have gone up 600% in just 1 year. I have included here a breakdown, and I got this from Access to Information that was actually posted online by another colleague, but temporary resident findings for the last essentially 10 years from 2014 to 2024, and you can see that every year it has increased, and it has just in the last 2 years particularly it has just become out of control. And there's different reasons for that, and it jumped down for a second to 0.4. There's a lot of increased technology use, right? And I think people need to understand the big picture here. And I want to take a few minutes to talk about this. Applicants, whether they maybe are just not careful when they make their own initial applications, maybe it was because IRCC was so lenient in the past with regards to if you weren't accurate in your applications. They just filled out applications, they filled out forms, they didn't look at their work experience carefully, they didn't look at dates. Maybe if they were not sure, they just guessed things and wrote them down, and there was no serious consequences. But now IRCC is cracking down. It's using technology to find any discrepancies, different answers that you might have put into your study permit application, your visitor visa application, compared to what you're putting now into your postgraduate work permit or into your express entry application. They're flagging that. They're also able to find, all kinds of other evidence with regards to travels, refusals. They have a lot of information sharing with the US, and they now have a policy that they want to exclude more and more people. So they're using this blunt instrument of misrepresentation, and now they have the data, they have the policy, and hand in hand, this is creating a situation where more and more people are finding themselves having to respond to procedural fairness letters and findings of misrepresentation. And it's extremely difficult once you get to that point that they've found discrepancies or they've found incorrect information, or in the worst case scenario, they've actually found fraudulent documentation, right? I think in those cases, it's just like almost impossible to do anything about when it's fraudulent documents. But if it's incorrect information, it's still difficult to be able to justify that the applicant didn't know because they ought to know, and that they can't just say that I told my consultant, or I told my lawyer about this. There is an obligation for them to check. And I say all of this to say there's a lot that keeps us up at night, but as we work on our practices going forward, it's becoming even more important to make sure that we triple check everything, right? Like those statutory questions, the questions about military service, their work experience, everything, we get sign off from our clients that they're actually correct before we submit them. A lot of folks are contacting me these days with regards to they either filled out their own initial stay permits, or like some agent helped them in Iran or overseas, and now they're applying for permanent residence, and they're like, well, they just didn't write down all of my work experience, or I didn't think it was important. I just wrote I worked at the same place for the whole time. And they're very concerned about misrepresentation findings, and I think they have reason to be concerned because it is possible for IRCC to come back and find that they didn't previously disclose correct information. What is going to make this worse is the introduction of what's called administrative monetary penalties, AMPs, by IRCC. This is a huge topic right now. They had a presentation about it yesterday, IRCC. They were talking about, we're just trying to get unauthorized representatives or find fraudulent information, and we try to punish this behavior to prevent it. But I think the reality of it, and what it ends up doing, is that IRCC can initiate an investigation if they think that there's incorrect, fraudulent misrepresentation, etc. in an application. They can initiate an investigation and provide us as the representative with a short period of time to respond, and we have to defend ourselves. It would be saying you have been aiding and abetting, for example, the making of misrepresentation. And while on some level it's very good to try to prevent fraud, they're definitely approaching this, I would argue, in the wrong way, because they're going after the people like us who actually put their names on applications, right? Like, you want to be going after people who are in the dark, that their name is not in an application. But in any case, I think it's going to be highly problematic, because if there's instances where it does end up that there's something that's not right, then they can come back and put huge fines starting from $5,000 up to $1.5 million. So this is going to have an impact on our practices. It's going to have an impact on our insurance policies. I can imagine that, somebody could be dishonest with me, provide documents, and I would check it, but then if they get caught later, they would just be like, my lawyer told me to do this. And it's going to be extremely difficult to demonstrate otherwise. And that's why I think it's important to have these conversations now, that you do have these processes in place to check, verify, and keep your communications with your clients so that they can't turn around later and be like, you actually were the one who told me to fill out the form in this way. And hopefully none of us ever ends up in that place. And I hope that there's actually enough challenges that they don't implement this, but it does seem like that's probably going to happen. And when it does, we're going to have to be very, very, very mindful. It will probably increase everyone's fees, because you're going to spend a lot more time ensuring that, whatever it is that you're submitting, your client signs off on it, that you keep copies of that, because you don't know which one of them is going to turn around later and say that, yeah, Mrs. Yeri told me to do this or that. Dan, did you have a question?
Yeah, just a quick one. This is in addition to the CICC, right? This is This
This
is
is
IRCC.
and the crazy thing is, it's supposed to be.
And one more question. Are they going to inform us when the investigation begins, or they just do it in the background and you don't even know about it?
Apparently, I mean, I don't even know because I'm not sure what circumstances this would apply to. Like, because they talk about unauthorized reps. I'm like, you're not going to find the unauthorized reps. Their name is not going to be in the application. I don't know what you're talking about here. But in any case, they have this process. If you, you know, you go and you read what they published so far, they say that if they suspect that there is something, then they'll do their own investigation and then they'll let you know, like, let me know that there is some concern. I don't know in how much detail, and then I have 30 days to respond, right? And you also have to think about like what our duty is as representatives. We're supposed to, first of all, there's a duty of confidentiality, certainly as lawyers, and I think it's pretty much the same thing for consultants. It really doesn't matter. But we also have to advocate for our clients. So if there's different ways of presenting the same thing, not fraud, I'm not talking about fake documents, I'm not talking about that, but you know, if our client has job duties that could fall under two categories, but two knocks, and one of them has a higher score than the other one, then I would zealously try to get them into the one that's the higher one, right? As long as there's no lies and there's no fraud. Is that going to be something that we're going to be, you know, held to this kind of like weird standard on? And the problem is the decision maker on the visas are the same, like IRCC is going to be the one who's deciding on the visas. They're also the ones who are going to be deciding if there's going to be an investigation. They're the ones who make the determinations. I'm like, that doesn't work. It has to be something, even if you're going to do something, it has to be a separate entity. It can't be the same group of people because, you know, we're all humans. Like,
So what is this? This is going to court, or like how do
no,
you
it's not
defend
court.
yourself?
I don't think they have that. I think it's something within IRCC, and they have the power to also fine us. And I'm like, this is ridiculous. I'm pretty sure
So this
that
is a preemptive strike. This is
it
kind
is.
of a preemptive strike on us, saying that this is why we think you're guilty. We're giving you 30 days to prove otherwise.
Yeah. Yeah. I can understand one aspect of this, as I said, fraud prevention, wanting to make sure that people don't become dupes and don't encourage fraud. But again, the people who care about this and are licensed, paying insurance, blah, 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 are not the ones
Yeah.
doing this stuff, right? It's the other folks in the shadows that are charging tons of money, but their names don't appear, and they're never gonna get these AMPs. It's gonna go against lawyers and consultants, which
So I should have an extra paragraph in my retainer agreement, or should I have a separate just to
that's a
protect
good
our?
point. I think our retainer agreements will probably, if you don't already have language, or like you're required to provide accurate, correct information, review your things, but also as part of your process, making sure the clients review the application before it goes out, particularly the forms, and getting, like when they submit the documents to you, getting verification. These are, please verify in writing that these are authentic documents, these are your own documents, because the consequences of submitting incorrect or fraudulent documents is misrepresentation. If we're doing that actively, then if someone turns around later and says, oh no, they told me to do this, this is what they did, then you can provide that as like, no, I followed the step, this is my process. I know that's going to take, that's what I'm saying, it's going to make our services more expensive because it takes more time. It's just like a lot more, you know, the way that you go to a doctor, they're always typing away because they're making notes.
Yeah.
Because they're afraid of liability. Well, the same thing is going to happen to us. We're going to have to keep, we should already be doing it, but even more so of every single interaction to ensure that you can demonstrate later that if like anything that arises is not your fault.
Yeah, I know CPAs do this when they do their audit reviews. They say, based on the information provided by our client, this is our review of their statement.
Yeah.
So they put that line in there based on information provided by the client. So maybe there should be something like that from our side, saying based on information provided by the client.
In a way, you're right. I mean, when
CPAs
lawyers
are doing it already.
Yeah,
It's-
but that's accepted. Like if we, can you think about like if we did that, what would be the impression that an officer would have about the content of our applications? And I think, you know, as legal representatives, we're supposed to advocate for our clients, and that's why I find this to be troubling, right? I'm mindful of the time. Sorry, you know, I'm happy to do a whole session on this, or we could talk about practice management maybe in a whole different session, but I wanted to flag it because it is very important And you guys should definitely follow it up both with your college and also through any other sort of like group organization stuff that you're doing, because it's going to have big impact on everything that we do. Really quickly
Thanks.
going through top tips. I've mentioned this several times, clear communications, keeping them appraised from the beginning about the various risks that there are, that things can change. If you don't already have, make sure you have provisions within your retainer about changed circumstances, and also talk to them upfront of like, this is not necessarily just an application for study permit. It might require you to go to court. It might require you to get a second PAL, like all of these things that could be part of the process so that they're aware of it from the beginning. And there have been, I was going to go into a little bit on court decisions. There's been some fantastic court decisions, but there's also been court decisions that show us the limitations of judicial review. Judicial review is only helpful if the underlying applications that's submitted is very complete and has meets the required regulations. If they're not, there will be some lawyers who will agree to take that to court. You know, they'll take your money, but those are not applications that are going to be successful. And unfortunately, they're probably going to end up being decisions that can hurt everybody else because they'll become precedents there as well. So JR is very helpful, but not in every circumstance. Anytime you're applying for anything, go back to basics, go back and read the regulations. I had one case that came to me for JR because a work permit was refused. And unfortunately, it was actually on the ICT MNC change. They applied one day after the changes came into effect, and they no longer met the requirements. And I know that they must have spent months and months gathering their documents, but just based on the day that they submitted the application, we couldn't do anything about it because they did not have two operations in two countries before they were starting their operations in Canada. And keep copies of everything. Not just communications with clients, but copies of applications, copies of all correspondence, and proof of online submissions. So when you do web forms, it doesn't give you a printout. You keep your own screenshots, though, and make sure it has the dates as well that you can have. Those are extremely important. They can be very helpful. They can save your client and yourself in some very difficult circumstances. And have contingency plans and think about professional insurance. As I said, because of this whole AMP thing and also increasing refusals and the kinds of stuff that they were accepting in the past, they are so strict about now that your clients will be like, well, you should have known about this. But you're like, but they weren't acting like this. In any case, you might consider increasing your insurance policies and keeping maybe a fund within your practice for essentially compensation or refunds to clients because of things like that. I'm not going to have a chance to go into my predictions, but I will leave them with you. Unfortunately, I think that we're going to see a lot more refusals, and we might quite possibly see a whole new government and so a new Minister of Immigration before the end of 2025, and I'm pretty sure have a new one in 2026. Things are going to continuously change for us. If you have questions I didn't get to, you can email me, but if we do have time, I'm happy to answer a couple more questions before we sign off.
Hi, Zainab John. I have a quick question.
Sure.
Could you just share your statistics that you run, statistics report for how much refusal they have and how much was for the number of the fraudulent document that they find out? If you don't mind, that share that page with us, and we appreciate it.
This one, right?
Yes, this one. Is it possible
I'm going to send up, yes, my presentation slides should have been sent before the session, but I was making changes, so it will be sent to everybody afterwards. Yes.
Appreciate. Thank you so very much. Thank you. It was great. Thank you.
No problem. Charbel?
Hi, okay. If someone is here in Canada on study permit and his spouse on a visitor visa, and they are from Iran and they like to apply for this Iranian program, can I still apply for work permit for the one who is studying? Like he's already in school.
Yes. There's nothing that says you can't hold a study permit and a work permit at the same time. It is possible, so you can do it.
Okay, good. The other question quickly also for the postgraduate who just graduated now and she wants to apply for her spouse. Is she eligible to apply for the spouse with her application?
She would have to provide proof that she has a job that's a skilled job in order to do that, I think. And also would have to be eligible for like a longer term postgraduate work permit. So and that was before they changed and increased the eligibility. If you remember, when we used to do postgraduate work permits for spouses, we had to provide evidence that the main applicant was working as in a skilled occupation. So it would kind of be the same thing here.
You mean like the same as the changes, tier 01?
Yes. Yeah.
So if tier 03, they want
unless the main applicant is in one of those special, like in the enumerated, like in-demand occupations.
It's similar to what's happening, like the usual happening now.
Yeah, that's right.
Well, thank you.
Behruz? Maybe Dan?
Yeah, just the last promise. Last question. So we have, I'm sure all of us have in Canada work permit applicants. We're applying to New York, right? I haven't heard back from them. It's been 4 months since my oldest one is in process. What happens when they get approved? So we're not doing flagpoling anymore. So what are we doing? So do they have to go, for example, is a Filipino or an Indian national, are they supposed to go back to India? So what's the point of staying here?
Yeah. Unfortunately, I think that's the case. They did talk about the possibility of opening up something inside of Canada so that people can apply and like get documentation, but there's been no progress on that at all. I haven't heard of anything that's actually been done. I think that would make sense, but unfortunately, I think at this point, people will have to go back, either home or they have to leave and
Mexico for 3 days.
Something like that.
Make a trip.
Yeah.
So it's only allowed at Pearson. It's only allowed at the airports, not at land borders.
True, but I mean,
you know what I'm asking? It's not. It's not
if you drive into
it's,
exactly, yeah. But if you,
it's not flagpoling though. It's an approved visa.
It's an approved visa, so you could get it on entry. So what you're saying, for example, is what if someone goes to Mexico for a week and then goes to the US and then from the US drives into Canada, right? That's what you're asking?
No. What I'm saying is they're approved. The passport is in my office with a sticker on it. Now we have to take them to Niagara Falls and just tell them, just print this out like we used to
But
before,
they don't
right?
do that anymore. That's what I'm saying.
Yeah, so
They
when
would
we
have
called
to
the
do
border, somebody called the border, not me. Ambassador Bridge says go to Mexico. That's what CBSA is saying.
Yeah. You'd have to essentially, as you said, fly back in. Like they want you to leave the country, obviously not go through the land borders, so not to the US. And then on your re-entry, be able to get it, but then be very mindful that they are asking a lot more questions. So again, we're preparing clients that are coming in through, whether it's the land border or through the airports, they have to be very mindful of like what their application is, what kind of questions they might be asked. I've seen situations where they're asking like very detailed information about their. Sorry?
It's an approved visa.
It is an approved visa, but I can imagine on work permits for someone who's been inside of Canada and did not have a work permit, they will try and find ways of asking them, like if they were working in Canada, try to determine if they are inadmissible because they were potentially working illegally here. They're going to be doing stuff like that. I know that they're already doing that. They were doing that before at the land border when people flagpoled, but you can imagine now that they're coming in through the airport, the officer could also ask them some of the questions. I've had people not necessarily
all over again. This is after getting an approval.
Yes. I've seen that.
That's crazy though.
I agree with you, but what isn't in immigration these days, Dan? Everything is crazy. Yeah.
Okay. Thank you.
No problem. Behruz? I know you're there because you unmuted a minute ago.
Do you hear me?
Yes, now we hear you. Go ahead.
Okay, how does Section 16(1) of the Act, which says a person who makes an application must answer truthfully all the questions, that section I'm talking about. How this is applying to the application where I just explained earlier. This couple want to apply and they don't want to mention the son. And if on the portal I don't submit the family information, there is no other question asking for the son. So is this basically not truthfully answering the question, or is not? Do they legally allow not talking about the son or not?
Well, this is interesting, right? So going back to, I'm glad you raised this because I actually forgot. So when we were talking about the A&P, you know, there might be a situation like that where without the A&P regime, you would tell your client, well, you don't have to declare everything because it's not necessarily relevant. So if you have an invitation from a friend or another family member, and you also go through that portal that doesn't require an additional family form, then you don't have to say your son is here, and you don't have to say that that he has a refugee claim, right? Right?
Right.
But when you look at the language that they're using around the A&P is, what if the information that you tell, the advice you give leads to the officer making a decision in one way or another, right? So
Right.
they could, if they found out that there was a child in Canada, say you should have disclosed this, and by not disclosing it, you were trying to impact the decision we were making. And then in that situation, your client could turn around and say, well, my representative said to do this. So in this kind of situation, what I would do is write to the client and say, we should include this information. Obviously, these are the positive points about your file, that you have prior travel history, that you've never overstayed, blah, 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 blah. And this is your son, and because he's done a refugee claim, he can't come to see you, so you want to be able to come and see him, right? And if you do not disclose this, and we submit the application without clearly disclosing this, and they find out, you could be found to have misrepresented. And your client decides what they want to do at that point. If they decide, no, I still don't want to go into detail on this, let's just do it based on a friend's, invitation, then you're like, you have proof that you had this conversation, that you were not trying to create a situation where you were deceiving the officer, right? And if it comes that there is an issue later, you can use that email exchange, right, to be able to demonstrate it. And on the other hand, if they decide, because they see what your advice is and they disclose it, then again, you clearly put that into writing. So I know that particularly a lot of clients from overseas don't like to communicate in writing. Like, I will send them emails and then they try to call me. And then I will just send another email, but like, you left me a voice message and you said this, but this is my advice. This is what I think we should do. This is what I agreed on. I know they don't like it, but if there's an issue later, that's what I need. And that's what is important.
Is it that saying if you don't disclose anything, then that indirectly causes the officer to make a decision, then is misrep? What act is this? What regulational act is this?
It's section 40 with regards to misrepresentation, says whether directly or indirectly through what I can't remember the language, but there's omission in there. So by not disclosing certain things is actually misrepresentation too. Let me see.
Right.
Pull it up.
But the point is, if this son is not even their is it a child, but it's not a family member? Is it because he's 24 years old on that son, or is still considered family member?
It's still considered a family member. I was going to say, as part of this presentation, is if you're doing an application or your client's doing an application, do not use the new portal because it doesn't allow you to submit an additional family form. And that is a highly valuable document for the most part, because everybody's family members can be listed in that, and that can show ties to their home country. But in your situation, it would be different. It would be the kind of thing you want to use, because it doesn't ask you about children, right? And it doesn't ask you about family, which is different than if you did like a representative portal application.
Yeah.
And Zainab, sorry to interrupt. Can you please make sure that Fariba is the last question, because we have to terminate the session.
Absolutely.
Thank you so much.
Yes. Okay.
Zainab.
Yes. Did you have a follow-up for me?
Who, me?
No,
Yes.
Charbel
No,
and
okay.
Fariba are the next.
Okay, next question. Charbel?
Yeah, okay. So if someone has, like, with all these changes for the work permit and bringing the family along, if somebody applied for this LMIA before these, like in, let's say, in March, but now he's applying for the work permit, are they exempt? Does it follow the LMIA or follow the work permit process?
The work permit.
So
So
if
you're talking about the spousal work permit, right?
yes.
And if their work permit is going to be for 60 months or more, they can include their spouse. Plus it's, you know, a high level occupation. But if it's either a lower tier or it's going to be a 1-year LMIA, they cannot apply for their spouse.
Even if the LMIA was submitted like in March.
Yeah, it's work permit. Yeah, it's what's going to happen now.
Oh,
Yeah.
all right. Thank you.
No problem. Fariba?
Hi, Zainab. Thank you very much. You should be very tired now. I'm going to make it short. One question is that a client of mine who I'm applying for visitor visa for him, I've done it many times, so I hope I don't have any problem with that. It's just that one of the daughters came about a year and a half ago, and then she was a lawyer in Iran. She had some problems, so she came here and she applied for refugee. It was accepted and it is in process. She hasn't received the PR yet. Now I'm going to apply for the father. And should I mention that in my submission letter? She's not the one who is going to give the invitation letter. It's the other daughter. They have 2 daughters. Both of them are here.
Yeah.
The other daughter is going to give the invitation letter. Should I mention that she is in the process
I
of
don't,
getting?
I think that's a little bit different. I just looked up the actual language for Section 40. It says, you know, it could be inadmissible for misrepresentation for directly or indirectly misrepresenting or withholding material facts that could induce an error in the administrative law, right? So I think the difference there is, you know, Charbel's case. No, sorry, Dan's case was it? No, Behruz. I'm sorry, guys. It's been a long day. The case we were just discussing before was they have the one child and that one child is applied. But in this situation, if they have another child and, you know, the other daughter is essentially given the invitation, I think it's a less of a requirement to talk through all of their children that are in Canada. But I'm telling you guys, they have so much data on the back end, they can much more easily find that anyway. That it might be better to address it yourself in your submission letter and say, they're coming to see their children here, but these are their ties back home, right? Don't leave that risk of potential. I think it's unlikely to be misrepresentation, but even like they're hiding anything, be upfront about it. This child can't come, so this is one of the only ways that they can see her, but they have no problems themselves in terms of going back. They only want to come for, you know, couple of weeks. They have their work, their assets, the rest of their family back home. I have seen they are able to, it doesn't matter who's doing the invitation, they're able to search names that are related parties and determine if they have, you know, what kind of status they have in Canada. And so I think at the end of the day, you're better off as a strategy of including that information, but explaining it. And remember, so many of these applications are unfortunately refused. Now, it might be a little bit different if they have a prior positive immigration history and travel history, but it's a really high refusal rate. So if you think that there might be a reason that this might go to court, the more detailed your submission letters are and the more detailed their explanations of like their ties to their home country, the better the chance of success.
Okay. So you say that it's better if I mention it that it is in the process. Okay. And I have a question for super visa for parents. Isn't it that the child has to be a resident of Canada?
They have to, I think so, because they also have to have like income documents and things like that.
Exactly.
So
That's what I know about this because I've done it before. But a client of mine who I just applied for that Iranian work permit for them, the parents are here. their son is working in US and he applied for super visa and it was accepted. They issued the visa, they have the visa. I was very surprised because, based on the information that I have, he has to be here in Canada and he has to pay taxes and those kind of things. But I told them, are you sure that your son said that he is in US? And they say yes. Even at World Port of Entry, they have asked the father, where is your son? And he said that my son is in US, and they didn't say anything.
Again, very lucky. That person should go buy a lottery ticket.
Very lucky,
That
and I'm
does not
not. Yeah, I'm just thinking that maybe the son didn't say anything, didn't mention. I don't know, but I'm very surprised. So I thought maybe you have seen such a case, or if you knew we could do that. I mean,
I've never heard that before. I have heard something slightly different, which is for some Canadians, particularly Iranians, who are now working in the US and they aren't able to get visas for their parents to go and see them in the US. I have had situations where we apply for the parents to get visitor visa so that they can see each other here in Canada. But I think that's different from the super visa situation because the super visa has the other requirements. Yeah, they're either something's missing in that picture or they're very lucky. I don't know which one it is, but I hope it's not some kind of.
And he didn't mention that the father had to go. I mean, the father was as a military. He was working because he's a professor. He didn't mention that in his application, but I did today. I submitted and I said that he has been in military for 2 years, but he was working as a professor at the University of Tehran. So he was so scared, he didn't want me to, but I said, well, now that I know, I have to mention that in your application and in your best interest.
It's always better to disclose any of these errors yourself as opposed to be found out by IRCC, because then it's too late.
Yeah. Thank you very, very much.
No problem. Thank you, everyone.
I appreciate
I will
it.
send this presentation to the board so that they can send it out. I apologize it wasn't sent out in advance.
Thank you very much, Zainab Jan.
Thank you. Thank you very much.
We should apply for 2.5 TPD, not just for 2 hours.
Yeah, exactly.
Make it 16.
Bye,
Why don't we do that?
Bye, everybody.
Bye.
Have a great one.
Reza Jan, thank you so much.
Bye-bye.
Thank you.
Thank you.
Bye-bye.
Thank you very much. Thank you. Bye-bye. Bye now.